rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. This is the time set for oral argument in our case number CACB230383, Mark Finchem versus Adrian Fontes et al. Good morning. Each side is allocated 20 minutes for oral argument. Appellant can reserve a portion of your time for rebuttal if you wish to do so. If you wish to do so, you'll need to keep track of your own time at the podium clock. Out of respect for counsel and to avoid embarrassment, please make sure that your cell phones are off so our proceedings aren't being interrupted. We've reviewed the briefs. We've conferenced the case this morning. We encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and will be posted to YouTube in due course. So please, as you begin your argument, please tell us your name and the party that you represent. With that, Mr. Wilenchuk, you may proceed.
Thank you, Your Honor. I would just point out, I'm having a problem with my left ear today, and I apologize for that, so if I don't hear your question at first, please understand.
We will try to keep that in mind. Thank you for letting us know.
All right. Good morning, Your Honors. So I am here. As you know, I was not the attorney below. And in reviewing the briefs, here's the issue that I'd like to focus on today with the court. I'm not going to advance every argument in the briefs, I promise. I'll try to focus mainly on one point that I believe requires reversal on the sanctions against Mr. Finchem.
And Mr. Wilenchuk, yes, just so we're clear, you not only were not counsel before the Superior Court, you were not the primary author, you're not the author of these briefs. You hadn't appeared until after their file. Okay, thank you.
As you know, it was,
complicated, yeah.
Okay. Anyway, let me focus, if I can, in my time on one issue, as I said, really primarily, and that is whether Mr. Finchem challenged a sufficient number of votes shown in the case below to satisfy the motion to dismiss standard, and therefore his election challenge would not therefore be frivolous, but in fact meritorious. Now, he's not appealing at this time. Again, I was not involved, but he's not appealing the dismissal.
In fact, he appealed that and then dismissed the appeal, so that's kind of beyond our purview now.
Unfortunately, that is correct. So I won't focus on that issue, but I will say, while you ask that while I think the court, in fact, was divested of jurisdiction on the motion to reconsider at that point in time because it was a 54B final judgment that had been entered, the court did have the ability to consider all the issues, nevertheless, on the reconsideration, and in fact did consider what was submitted on the reconsideration. For the purposes of sanctions, I will argue that all those points are still relevant for the sanctions portion of the case. Anyway, the sanction was not warranted here. The claim was actually brought in this regard, and I'll show you in a minute, with substantial justification and in good faith under 12-349, which the court utilized. As you know, good faith is a subjective standard, and substantial justification would be objective. Now, let me focus, as I said, on the votes. The election was lost by about 120,000 votes as Secretary of State. Therefore, the number of votes the court held that Mr. Finchem would have to have a reasonable belief he needed to show to challenge, even if we accept the standard of the Finley v. Sorensen case, which is a case that deals with whether or not you can show that you've affected the result, or at least render it uncertain, which I think is important language. So, again, there were lots of different things thrown about, but we know, and Mr. Finchem alleged, that 80,000 votes went missing, and this was, I'm sorry? No, I apologize. The Superior Court acknowledged this and stated Mr. Finchem's expert report identified the 80,000 potentially missing votes, and the under advisement ruling at 4, but these were the only votes, really, that the court considered, as you'll see. Mr. Finchem also alleged in his amended petition that Maricopa County had changed the gauge of paper for ballots, which change was untested, resulting directly in 201,232 votes for Fontes that would have otherwise gone to him. I can give you the cites if you want, but it's in the record, including support from an expert the lower court rejected out of hand without a Daubert hearing or proper consideration under Rule 702. So here's what the expert, Mr. Schaefer, said. Somehow, quote, the print on demand ballot size got changed from 20 inches to 19 on some, not all, ballots that resulted in invalid, quote, rejected ballots by the tabulation machines. The number of rejected ballots has been estimated to be as high as 200,000. In my opinion, without independent review or audit of the DOR 3 duplication, all of these ballots should be deemed invalid and should not have been counted, amounting to the estimated 200,000. The trial court simply failed to address the allegations regarding these 201,000 votes in its order granting the motion to dismiss. In fact, the court said that, quote, none of contestant Finchem's allegation, even if true, would have changed the vote count enough to overcome the 120,000 he needed to affect the result of the elections, which was a major portion of her decision on both the sanctions and the dismissal. That's in her March 1st under advisement ruling.
Counsel, let me ask you, with respect to that point, procedurally, this is a little bit of an unusual case, given that there was an appeal from that substantive decision, which was dismissed voluntarily by your client, which kind of leaves that decision untouchable, right? And then later, or meanwhile maybe, to say it better, sanctions were imposed, and now that's what we're asked to do.
Correct.
So I understand your concern with that substantive decision, but how much of that is properly in play for us today, given that it's final on the merits?
I think it all is because the court found sanctions on the bringing of that complaint. So I'm trying to show, regardless of whether he voluntarily dismissed it, that the factors that went into that original pleading as well as in the motion for reconsideration were actually brought with substantial justification on their face, clearly for purposes of a motion to dismiss. We have to assume that. And secondly, were brought in good faith. Again, you have a 5-day window to bring this election contest. You can't possibly have all the evidence you could want, and you certainly don't have the ability to test all the evidence you want within 5 days, which is why newly discovered evidence was presented at the time of the sanction hearing, the motion for reconsideration and sanction hearing. So I think it's clear that as long as he alleged, in good faith, I mean, obviously, if he alleged sufficient allegations with experts to boot, with affidavits or declarations of people to boot, which is more than I think most people would need to do in a notice pleading situation, the fact is he did not just allege, as the court held, to be simple about it, that there were 80,000 votes that he was contesting. And the court's order, with due respect to the court, seems to state, essentially, that that's all he could muster a complaint about. But it's simply not correct. Now, look, in the election challenge itself, he did allege the 80,000, IR 28, but then he also alleged 201,000, based, as I was starting to say, on a change in the gauge of paper. That's IR 15. But then, at the time of the motion for reconsideration in the sanctions ruling, he brought forth evidence which the court, contrary to what my colleague would say, the court did consider. It's not that the court didn't consider it. She did. She just simply considered it wrongfully. She didn't analyze it and basically tossed out of hand. But the point is he showed, for purposes of sanctions, another 30,000 based on 260,000 votes going into Runbeck and 290 coming out. That's IR 374. 290,000 he showed through a failure to follow the chain of custody at Runbeck, which would render all of those votes invalid, IR 374. And another 300,000 signature verification issues at IR 838 in his notice of supplemental authority, which the court did consider. If the court considered that as true, and of course on a motion to dismiss standard, that is the test, regardless of whether he later dismissed that case or not, for purposes of sanctions, the court had to assume that these were valid facts pled. She just didn't even analyze them, simply saying, in conclusory fashion, I'll say, that they are basically irrelevant.
What's the best case supporting the proposition that for assessing sanctions under 349, the court is required to accept as true allegations in a pleading?
You're asking if the court does have to?
No, yeah, I'm asking what the best authority is that, because I get, if you're in 12b6 land, I completely understand that, but 349 seems to be a more searching...
That's fair. I don't really disagree with that comment or that point. I don't know that the court has to assume the truth of all the allegations for purposes of sanctions. However, there was really no contrary evidence at the time of the motion to reconsider and sanction award. You can see the orders that was really presented.
Well, and let me ask you there, is that required under 349 to dispute the allegations for purposes of sanctions?
Sure. I think that basically, the test, let me just turn to that. What does groundless mean? Groundless means that no rational argument can support the claim. No rational argument can support the claim under the Evergreen West case. Without substantial justification, even the court held, means it's groundless and not brought in good faith, both factors. That was in her order, in fact.
Is everything an expert says automatically above that bar, counsel?
I'm sorry?
Is everything that an expert says automatically above that bar? The fact that an expert says it, does that automatically make it non-groundless? Is that your argument?
Yes, our argument is that the court did not consider the points that we're talking about. There's nothing in her order at all saying...
Well, counsel, I take your point about didn't consider. I'm just saying abstractly, with Judge Thum's point about looking at what 349 means. Does the fact that an expert says it automatically make it non-groundless? I'm not asking about the judge's mental process.
Sure, I get it.
Okay, thank you.
I think it's the same answer I gave. There was no contrary evidence, as you would have on a summary judgment. So, yes, the answer is the court does have to assume that the expert is testifying in good faith. There's no 702 hearing. There was no challenge in that sense to the expert through any hearing.
Just to make an analogy, we sometimes get cases where there's an opening brief filed and there's no contrary brief filed, and it turns out the opening brief is wrong anyway. Sometimes people say things that aren't contradictory that are wrong.
Absolutely, Judge Jacobs.
Can't that possibly occur with experts?
It could possibly be, but it wasn't.
Okay.
Because there was no analysis.
Understood.
Yeah, I mean, I agree with your position or your statement, but there was no such analysis or controverting facts as you would have, or even challenge to what these witnesses and experts said. But the point is that regardless of the motion to dismiss standard or not, which I still think is important for the reasons I just said, sanctions were just simply inappropriate. This wasn't a case that was brought, to harm somebody, harm the system or whatever, game the system, whatever things sanctions are meant to do, to deter. They're not intended for punishment. We know that. Mm-hmm. What they're intended to do is to deter certain types of cases that should not be in the system. This is not one of those cases. This was a legitimately, researched, tons of information. Court may have rejected it. It may turn out that information turned out to be wrong in the end. But you can look at even the ethics rules to that regard. Under the ethics rules, if I can find it real quickly.
Counsel, with apologies for interrupting you, you're down to 7 minutes. I don't mean to yell, I just want to make sure I'm understood. You're understanding you weren't the trial counsel and you didn't write these briefs. Do you still maintain all the positions in these briefs, or are there any you want to carve away?
Good question. I would focus on this one issue.
But are there any, you're not disavowing the briefs?
To answer your question directly, let me get to that. Mm-hmm. I had written down, frankly, so if I can just turn to my note. I would waive the argument that the rules of civil procedure do not apply. Okay. I would waive the argument that parties cannot be sanctioned for bringing election challenges under Title 16. Right. The other arguments I would not waive, but I would not advance, if that makes any sense.
I just want to ask you about one, which I saw in your client's affidavit that was filed for the first time in this court, and also was picked up in the reply. Are you adhering to the position that a court should infer and this is paragraph 39 of Mr. Finchem's affidavit, 120,000 Republicans have never split their vote in this state. Are you adhering to the position, A, that that is true, and B, that it's a reason to question inferentially what happened?
Well, if you want my honest answer, my answer is I think the affidavit should simply not be considered, frankly.
Because?
I don't believe personally it was appropriately filed in the Court of Appeals.
Okay, so you would take the further position the affidavit is not properly before us?
I don't think it's something you should consider, yes.
Because it should not have been filed?
I believe that's correct.
Thank you, counsel.
All right, well, let me do this with the time running down. Basically, my position then, just so we're all clear on it, is that there was sufficient number of votes challenged beyond the 80,000. It's clearly in the record that was not analyzed or considered by the court. So I'll leave it at that to be simple. And then I would also just point out a couple of things before I sit down and reserve my time. There was really no controverting evidence, as I said. There was some stuff in footnotes, there was questions about some of the evidence, but there was no controverting evidence. I also want to point out that Ethics Rule 3.1 in Comment 2 makes it clear that the filing of an action taken for a client is not frivolous merely because the facts have not first been fully substantiated or because the lawyer expects to develop vital evidence to do so in the discovery phase. That is not a basis for sanctions. And finally,
Counsel, on that point, though,
Yes.
the trial court didn't impose sanctions based on frivolousness. It was without substantial justification, correct?
well, I think the case law is candidly that Rule 11 frivolousness standards are pretty much the same thing.
And I understand that, but I didn't read the court imposing sanctions under Rule 11. I read the court as imposing...
She said that the standards were basically the same, but she chose not to do it under Rule 11.
But even more specifically, 349A1, not the other subparts.
Well, I'm unclear on that, to be candid, because I think her order also said she did include the two factors, the bad faith. But I agree with you. I think it's primarily should be on A1.
But that's a definition, statutory definition later in the statute of substantial justification, right? That's why, say, I read it as an A1 sanction.
Exactly.
Okay.
That's correct. And if that's the situation, you don't get into good faith or not. Let me just close then by saying, and reserve my time by saying, the only other final point I want to raise that isn't in the briefing is that counsel refers to the Court of Appeals opinion in Arizona Republican Party versus Richer. I just want to point out, I think you're probably aware by now, but I'm involved in that case. The Arizona Supreme Court has accepted review, so I would just ask the court to note that it shouldn't be used as...
We are aware of that case and aware of that fact. Thank you, counsel.
All right, thank you.
Thank you. Mr. Moore?
Good morning. May it please the court. My name's Craig Morgan. I'm with Sherman & Howard, and I represent Secretary of State Adrian Fontes. This is a case about accountability, plain simple. This is a case about defending our judiciary and the sanctity of our judiciary. This is a case about the rule of law. This is a case about what happens when you cross the threshold between the public and that bar, and you assert claims without justification. This is a case about consequences. I appreciate Mr. Wilenchek's argument. I more than appreciate his concessions. But the fact that there was a dispute about the votes below, the fact there's a disagreement about how the judge counted those votes, who cares? That's not the only reason Mr. Finchem and his lawyer were sanctioned. They were sanctioned for many reasons. They were sanctioned for making arguments that our democracy can't be trusted, that our electoral system is broken because the governor deigned to do her job while Secretary of State and refused to recuse herself, because someone wrote to Twitter and told them, stop misinformation, and Twitter, a private actor, suspended an account. Somehow that's official misconduct. Somehow that means there were illegal votes. They sued one county, Maricopa County, and they alleged that an entire election needed to be overturned because that one county had machines certified by person A and not person B, machines that had been certified for years. We're here because this case, it had no merit when it was filed. It had no merit when we got to court. It has no merit now. We're here because positions were taken that frankly were unfathomable, were unthinkable in my 20 years as a lawyer, as an honored member of this bar. That's why we're here. We're not here to worry about the merits. That ship sailed. Nobody's appealing the merits. And to address your point directly, to address this court's point directly, no, I'm not aware of a single case that says on review here, we can go back and reconsider the merits.
But don't, counsel, we have to, how do we decide what without substantial justification means if we don't at least take a peek at the issues? I mean, I think that in the, for better or for worse, in the Republican Party case, we went into some painstaking detail in that decision. You know, the Supreme Court, you know, may feel that that was not the proper thing to do, and they'll let us know. But I don't know. And the case is, there's not a lot of case law in this area under 1235, as you might be aware. So there has to be a method by which we approach that. So I'd appreciate your thoughts on how do we, I understand the appeal was withdrawn, I understand that, but Mr. Willencheck is raising some arguments here that do resonate to some extent in the fact that we have to look at something to decide whether the Superior Court erred. What do we look at?
I think it's fair to look at the record. I think it's fair to look at the record. We look at the application right of 12-349 de novo, but we look at the court's factual determinations for clear error. That's all you need to do. And I submit to the court that if you do that, even if Mr. Willencheck's right that they truly, truly believed when they walked into court that their expert was right and that the votes, let's give them their numbers, let's give them their numbers. If you read the decision and you look at the record, you're not going to find that the judge committed clear error. And that's your task. And that's why we ask that you affirm.
Which particular findings are you pointing to that are strongest that necessarily make it so that the claims were without justification? Which point us to your best findings?
Well, for starters, Your Honor, I'll work backwards. I'll address all of them. Let's start with the Twitter argument. Okay? They're saying that because someone at the Secretary of State's office alerted, probably arguably, I don't know, I'm going to say it's not the record, the world's largest social media platform, that there may be misinformation, and that platform took action, that private actor, that somehow that was misconduct that warrants an election challenge. That's a reason. That's without substantial justification. Or the fact that the sitting Secretary of State, notwithstanding the fact she was running for governor, took an oath to do her job and did it and refused to recuse herself. Somehow that was misconduct, giving rise to an election challenge. Or the fact that she had the nerve, the temerity, to reach out to Mojave County and say, hey, do your job, or I'm going to do whatever I can within my power to lawfully have you do it. Somehow that gives rise to an election challenge. Okay? But that's not it. Let's talk about what happened after we filed the lawsuit, after they got the safe harbor letter under Rule 11. Let's talk about arguing in front of the court, in front of the public. This is an election challenge, the rules don't apply. That was without substantial justification. Let's talk about refusing to concede the fact that this is a case in front of a court and that you have to follow its rules, not just then, but in front of you. That lacks substantial justification. And that can't be lost. It can't. We're not here because of one issue. We're not here because of an issue that's not on appeal. It could very well be, and I don't know where it is in the record, it could very well be that Judge Julian went and looked at the canvas. Let's talk about the canvas, the Maricopa County canvas. In Maricopa County, there were 111,116 votes. That's the margin of victory. The total votes they want to have kicked are 120 to 108. The difference, 9,092. I think that's the right number. 9,000 and change. My point is, kick the votes. You're in. the record, we don't know what Judge Julian was thinking beyond what's in the four corners of her decision. And that's the decision we're stuck with. And I'm not happy that we're here about this. My client is absolutely not happy we're here about this. But here we are, because the rule of law matters. And we ask the court to affirm. And we ask the court to sanction Mr. Finchem, sanction his prior counsel for what they've done in this court. You've read my papers. I'm not going to reiterate it here. But we have to stand up for the integrity of the judicial system, or this whole democracy falls. Are there any other questions I can answer?
Thank you, Mr. Moore.
Thank you. Out of respect for Mr. Willenchik, of which I do have great respect, and if it pleases the court, he can have as much of my remaining time as he likes. Thank you.
Thank you.
First time that's ever been offered.
I defer to your better judgment on all you do.
Take him up on
I'm sure it's a new one on you too.
Mr. Willenchik.
Look, I can try to, as lawyers always try to say, be brief, but the truth of the matter is, counsel, and he is a good counsel, wants to talk about a lot of things and the rule of law and make a jury argument here. But here's the rule of law that the court cited at page 2 of her order on March 1st. The moving party bears the burden of demonstrating by a preponderance of the evidence that the claim was both groundless and asserted in bad faith. Quote, with the absence of even one element rendering the statute inapplicable. That's the Vallis case. Now, my point of being up here today, because the counsel below couldn't be here, apparently, long story with the State Bar Association, I guess.
He withdrew. You're right.
Yeah. But my only point of being up here is not to try to pull a fast one on the court. My point of being here is in looking at the briefing, what I see is, and the orders, that counsel has never addressed, with all due respect to him, that there was more than 120,000 votes that were at issue that clearly could have made the difference. There was, frankly, close to 900,000 votes by the end of the tally here, when I add up the numbers, that close to 900,000, I should say, 871,232 is the exact number, that is the running total by the time of that sanction award that they had presented below. And I do want to distinguish between counsel and Mr. Finchem while I'm at it, because the fact is that there is a distinction, as you well know. I've represented lawyers in cases, you said there was a dearth of cases. I was the attorney in the Goldman v. Saul case, and one of the few cases on the subject. But there's a distinction between attorneys and their clients, as you point out. And the fact of the matter is that most of the court's wrath at pages 4 and 5 of the sanctions order, as I recall it, is directed against the attorney, not Mr. Finchem. What is Mr. Finchem's role in this? Mr. Finchem lost the election, clearly by a margin of 120,000. That's how this starts. And he presents sufficient evidence on a motion to dismiss standard, which again I do invoke as being relevant because that is the standard by which they presented the evidence. They didn't present the evidence in the context of a summary judgment or a trial. They presented it in the context of a dismissal motion. And in that context, the court is, of course, having to rely that these are truthful. Now, if the court then says, and I agree with Judge Thoma, if the court then holds a hearing and finds that this evidence was presented without substantial justification at all, or in bad faith, or both, then I would agree with everything my learned colleague is saying. But that never happened, and he, with all due respect, never presented that evidence to the court because he didn't have to on a motion to dismiss. So we don't, to answer Judge Brown's question, have the record at all here flushed out that any of this was without substantial justification at all. And I would submit that in the context of a complaint, that presenting and providing expert opinions, declarations of people who were involved in the election, I could spend his 12 minutes going through all that if you like, but you have the record. You know the declarations I'm referring to and the statements made, so I won't bore you with just reading them verbatim. But they were presented to the court, and the court never analyzed any of it. But here's the thing. The court did, contrary to counsel's insinuations, the court did consider it, stated it considered it, and then simply didn't analyze it at all. Now, if the court did analyze it, I wouldn't be up here. If the court analyzed it, I would never have entered my appearance here. But as I review the record, that never happened. And to award sanctions, and the court, is mindful of this, and this is what's so painful to me. The court is mindful, quote unquote, of the caution with which sanctions should be imposed. The court should be, because sanctions today, and I'm involved in a lot of these matters in state and federal court arguing this, sanctions today are all too often granted far too easily, and particularly in election-type cases. And it does chill, whether you're Republican, Democrat, I don't care. It works, in reverse on another day. It's wrong to just sanction lawyers and their clients for bringing actions within 5 days to contest an election and expect them to have basically proven their case that goes on for perhaps a year after. And that's why I cited the ethical rule, because even the ethical rules acknowledge this point. The key is to raise the issue in good faith and with substantial justification, which means that there's some rational basis to believe that if you're correct and if it pans out that you're not going to be sanctioned. I applaud, frankly, people that dismiss cases where they later learn that some of that does not pan out for various reasons. You should applaud that, not sanction it, because that's exactly what lawyers should do. But to sanction them for bringing the action when they have evidence and to expect them to have basically, run their whole case through the ringer within 5 days is absurd. And this court even didn't do it because she didn't have to do it. She ruled on a motion to dismiss, but she did have to do it on the reconsideration, which is why I said I'm here. Because at that point, when she's considering it, you can read her own words. She simply doesn't analyze it at all. She just dismisses it out of hand. There's not one word from either opposing counsel or the court discussing any of it. Now, there's lots of words of counsel, again, attacks and so forth, footnotes that refer to the fact that these are conclusory allegations and so forth. I beg to differ, frankly. They're not conclusory when you submit affidavits of people. They're not conclusory because the court just simply doesn't buy, for whatever their political reasons or otherwise, what the expert is saying.
Counsel, let me ask you, on the factual side of things, I understand your point that the court indicated it considered the filings, and you indicate it didn't analyze those, at least not in writing. But for factual issues on sanctions, it is a clearly erroneous standard, correct? Do you dispute that? Not the legal issue, which is de novo for her, but the factual issue, factual
Yes,
findings.
I would agree with that. But the problem with that, Judge, is that we have nothing in the record. We've debated this many times about whether there has to be anything in the record to support, the verdict. I'm critical of that approach because it's absurd. There's always something. But in this case, let's be serious, there was no analysis whatsoever. No hearing on the experts.
Then we understand your position.
Yeah, okay. I'm not going to repeat myself. I think at this point, let me just say this. I agree. I'm not here to give closing arguments, and I respect counsel, and I didn't mean to be pejorative by saying that, but I meant to say that arguments are not facts. And you disagree?
No, I strongly agree that arguments are not facts. There is a difference.
Arguments are not facts. But I believe what was presented here was factual. It's not just argument. It wasn't just a pleading that said, that we lost by 120,000 votes, and if we have the time, we can figure out a way to make them up. No, there were specific factual things. Now, you may disagree with those. That's fair, that's fine. We all can disagree as lawyers and judges. But that doesn't make it sanctionable. That's my point here. Thank you.
Thank you. Counsel, we appreciate your presentation today.
With respect to something I said, I think I need to make sure I clarify it for the record.
Speak to the microphone. I'll hear if Mr. Willinchek has a response. Mr. Morgan.
Ms. Hartman-Taya is reminding me a moment ago why my malpractice insurer won't let me do math. I just want to be clear to the panel. The 111 votes, okay? That's all the votes.
111,000?
111,000 votes, thank you. Judge, as I said, my malpractice insurer does not let me do math. The 111,116 votes in Maricopa County, those are all the votes just in Maricopa County, okay? The 120,000 and 208 votes, that's the difference between Mr. Finchem and Secretary Fontes in the race, okay? The 9,000 and change is if you cut out all of Maricopa County's votes and you just count all the remaining county votes. My point being that even then, there's still a 9,000 vote or so difference. I just wanted to make sure I clarified that because, again, I have no business doing math.
Thank you, Mr. Morgan.
Thank you.
Mr. Willencheck, I'm sort of guessing you have no response to that.
I'll just repeat very quickly, Your Honor, that we aren't making his arguments. We're making separate arguments that are in the record, IR 374 and IR 838, in the motion to reconsider, which clearly amount to 30,000, 290,000, 300,000, beyond the 80,000 and 201,000 at IR 15 and 5 and 16 that were in the original challenge. So we're not addressing his issue.
I appreciate that. Thank you again, counsel, for your presentation today. We will take the matter under advisement. We'll issue a written ruling in due course. Court stands adjourned.
Thank you, Your Honors.